Thank you, Madam Speaker, and good morning.
Good morning, sir.
If I may, a few questions through you to the proponent of the bill.
Please prepare your questions, sir.
Thank you, Madam Speaker. I think I've done a good job. I had a host of questions. I've tried to pluck my yellow stickies as best I can as people have worked through it, and I apologize if I missed a few. But I'm going to work through the bill, just a few questions, if I could. Through you, Madam Speaker, to the gentleman. I'm looking at lines 168 through 172, which I believe it's section, it's probably 2, but it doesn't matter, I.1. It speaks of how no member of the board or any officer shall directly or indirectly have any financial interest in any corporation that has, or entity, that contracts with the authority. Through you, Madam Speaker, what, if any, prohibition does this bill have against any officer, agent, or employee of the authority who may be a major investor in one of the investment vehicles of the fund, or a fund that's run by the, or used by the authority? Through you, Madam Speaker.
Representative Terciak.
Thank you very much, Madam Speaker. Nobody has a right to be on this board. If one of these restrictions applies to them, then they can't be appointed to the board. Through you, Madam Speaker.
Representative Shaban.
Well, thank you, Madam Speaker. And I think that's a truism. If a restriction applies, they can't be on the board. But what I was looking for when I was reading the bill was a restriction on someone who has a direct and substantial interest in any of the financial vehicles that this authority may be investing in. Through you, Madam Speaker, does such a restriction exist in this bill?
Representative Terciak.
In that would, if that were a fiduciary violation, then federal regulations about fiduciary responsibilities will cover it. Should it not be a fiduciary violation, there would therefore, I guess, be no problem with it happening, and therefore there would be no federal law or state law against it. But with the new federal regulations on fiduciary responsibilities, that's where it comes in. We don't have to regulate it. We don't have to reinvent ERISA. We don't have to reinvent the federal regulations. They're there. We'll let them be applied as they should be. Through you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. So is the gentleman saying that that prohibition need not be in our state law because this law is governed by the provisions contained in ERISA? Through you.
Representative Terciak.
I think I was asked a yes or no question, and I don't think that either yes or no is the right answer. Could try again, and I'll try harder, please, if it's okay with you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. Yeah, I had asked a question about potential conflicts of interest in having a substantial ownership interest in some of the investment vehicles that this authority may have, and the gentleman said, well, that's covered by the fiduciary responsibilities governed in ERISA. Through you, Madam Speaker, is it the gentleman's response then that this, or the provisions of this bill are in fact covered by ERISA? Through you.
Representative Terciak.
Thank you very much, Madam Speaker. Aside from the amendment we accepted as friendly earlier, there are no violations of ERISA in this bill, is what we're being told. And in terms of the state involvement, what this bill is the state being involved in saying who can and cannot be involved, be a member of the board or an officer of the employee of the agency. Through you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. Well, I guess it's a little bit of apples and oranges, asking if there's a violation of ERISA or, in fact, the provisions of this act are covered by ERISA. I think the answer stands on itself that the potential conflicts with someone on the board, at least legislative authority, legislative intent, the fiduciary responsibilities, to the extent there are fiduciary responsibilities, are in fact triggered by what I heard, federal regulation and ERISA, which actually tees up the next question. Through you, Madam Speaker. Looking at lines 209 through 215, if we would. It actually mentions the ERISA, some of the ERISA, at least it cites to ERISA to a certain extent, making that the board has the authority to make modifications to the program that the board deems necessary to do what needs to be done in sections 2 through 13, and to meet all criteria for federal tax deferral or tax exempt benefits, and to prevent the program from being treated as an employee benefit plan under the Federal Employee Retirement Income Act of 1974 as amended from time to time. Through you, Madam Speaker, what does that mean? Through you.
Representative Terciak.
Thank you very much, Madam Speaker. An attorney probably would tell, who specialized in this area would say, what it means, what it says. And I might be satisfied with that too. It means that the board has some say over the program in designing it and implementing it. It says that this will be consistent with federal rules and regulations to make sure that the program meets all the criteria for tax deferral or tax exempt benefits. As we have previously mentioned, offering this plan is going to allow employers to be eligible for federal tax benefits. And to prevent the program from being treated as an employee benefit plan under the Employee Retirement Income Security Act. Mention again, Roth IRAs are savings programs. They are not a defined benefit pension program. It's a savings plan. And have to make sure it's treated that way and not as a pension, since it's not a pension. And it also says, as amended from time to time, so that should the rules change, they have the authority to have regulations comply with those rules without having to come back to us to get permission to have regulations to comply with federal rules. I hope that's helpful, Madam Chair, through you.
Representative Shaban.
Well, thank you, Madam Speaker. So, if you would, do you agree with me, would you not, that under this bill, as amended by this amendment, that the employer is now required to establish whatever this income deduction is to effectuate the savings anticipated in the bill? Is that correct? Through you.
Representative Terciak.
Thank you, Madam Speaker. I think that's too broad a statement, so no, I don't agree.
Representative Shaban.
Thank you, Madam Speaker. If the gentleman could explain the broadness or what needs to be narrowed, so I could ask a better question. Through you, Madam Speaker.
Representative Terciak.
I don't understand the discussion, the part of the discussion about liability under this. Where we've worked very hard to shield employers from liability, and as long as they have either another program or having no other program, then they would be eligible for this, sign up for this, then there's no other response, then they don't have further liabilities after that. Thank you very much, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. Well, perhaps I misspoke. I don't think I used the word liability. What I was trying to establish that pursuant to this bill, in fact, our employers, covered employers under this bill, will be required to establish the deduction from the paycheck in order to effectuate the savings anticipated in this bill. Through you, Madam Speaker.
Representative Terciak.
Yes, Madam Speaker, there is nothing in this bill that changes the employer's responsibilities as it comes to paychecks. Thank you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. And so once the employer establishes the program and deducts the 3 or more percent, is it true then that deferral of income by the employees will extend for a period that will terminate at some point in the future in anticipation of retirement? Through you, Madam Speaker.
Representative Terciak.
Thank you very much, Madam Speaker. It's true that when a person retires, they will no longer, their employer, when they're no longer giving that retired person paychecks will no longer be responsible for making sure there are deductions from the paychecks that won't be existing because the person's retired and not being paid. Through you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. And so when that retirement comes, that is when the employee will be eligible to receive those benefits. Is that correct? Through you, Madam Speaker.
Representative Terziak.
Thank you very much, Madam Speaker. Eligibility for receiving benefits will be the same as they are for other IRA programs. Thank you very much.
Representative Shaban.
Thank you, Madam Speaker. Well, I think it's interesting that the basic construct of what we're talking about here follows almost verbatim the definition under ERISA for what an employee benefit plan is. And if anyone has had the unfortunate experience of having been involved in ERISA law or ERISA litigation, will know that you run aground or you run afoul of ERISA preemption because, in fact, it's quite broad. Because, in fact, the Supreme Court and all our federal courts and the Connecticut federal courts and federal courts all around the country since 1974 have established and defined the breadth and the scope of ERISA preemption. And I fear, Madam Speaker, that we are running dead afoul of exactly that. Now, again, you've heard me stand generally in this spot. I move around a lot, talking about states' rights and what the state can do and can't do vis-a-vis federal law. And if it's the intent of the state of Connecticut to say, you know what, federal government, we don't care what you say. We don't care how we're going to treat our employees or how you think we should treat our employees. We're going to do it our own way. Well, that's one thing. That's quite a broad statement. It might violate 35, 40 years of federal precedent, but I'm a states' rights guy. I kind of like that. I think that's a bold statement. I think the state of Connecticut does have the authority to pull back some of the federal preemption that we've ceded to the federal government over the last 30, 40, 50, 60, 70 years. But here we're faced with a bill that tacitly admits at lines 213, 214, and 215 that, you know what, we know this thing runs afoul of ERISA, but we're going to put some savings language, put some new language in here. This is new language. This wasn't in the original bill that says, well, whatever we got to do to make it right, we're going to do it. Doesn't say what you're going to do. Doesn't say how you're going to do it. But the gentleman was very clear that what's happening here is we are establishing an employee benefit plan that is going to be deferred income until someone retires. That is covered by ERISA. That is on all fours with ERISA preemption. And through you, Madam Speaker, has the Attorney General offered an opinion on this amendment?
Representative Terziak.
Thank you very much, Madam Speaker. I haven't asked him if he sent me something during the debate. I haven't paid attention and received it, and no, he hasn't. As far as I know, he hasn't reached out to me with an opinion. If he's voiced an opinion to somebody else, I'd have no way of knowing. Thank you very much, Madam Speaker. Through you.
Representative Shaban.
Well, thank you, Madam Speaker. So when the amendment was drafted, in lines 213, 214, and 215, to require this board to take affirmative action to make sure this thing does not run aground of the federal preemption laws under ERISA, did anyone on that drafting committee or the body or the committee actually get legal advice to how that could be done? Through you, Madam Speaker.
Representative Terziak.
Thank you very much, Madam Speaker. Yes, through you.
Representative Shaban.
Thank you, Madam Speaker. And was that legal? And what was that advice to the extent? Was it from the Attorney General? Through you, Madam Speaker.
Representative Terziak.
Thank you very much, Madam Speaker. If it had been through the Attorney General, I would have said that was the Attorney General's response and advice on this issue. But no. Thank you.
Representative Shaban.
Thank you, Madam Speaker. Well, I suspect we're going to get some advice and input from the Attorney General soon on this, because this chamber may remember 3, 4, 5, 6 years ago now when we were doing a captive audience bill that ran aground of the National Labor Relations Act of 1934. I think I was standing right here with Representative Berthel was, and we had this exact same discussion about whether anyone had actually run these bills by the Attorney General to see if in fact they are legal under our federal construct. The answer then was no. Guess what happened? Attorney General months later said, guess what? You can't do that. And that went away. I fear this is what's probably going to happen here, but not to belabor the point, through you, Madam Speaker, are the assets in this IRA exempt from bankruptcy? Through you, Madam Speaker.
Representative Terziak.
Thank you very much, Madam Speaker. The assets in this IRA are exempt from bankruptcy or not exempt from bankruptcy, exactly as assets are in IRAs. Thank you, Madam Speaker.
Representative Shaban.
Well, thank you, Madam Speaker. And that, too, is another telling response because, in fact, IRA benefits are exempt or not exempt from bankruptcy, depending typically on the state law in which they exist, unless they're covered by ERISA. Because under ERISA, they would be exempt from, or they would be subject to bankruptcy protection. They could not get attached by creditors. But here we go. We go from having a standard IRA, which puts in pre-tax dollars, to having a Roth IRA, which puts in post-tax dollars. Through you, Madam Speaker, why was that change made in this amendment? Through you.
Representative Tersiak.
Thank you very much, Madam Speaker. It was made to make the bill more fiscally responsible and basically for it to work. In order to have a defined benefit plan, one needs to have more than just the money that was put in and the ability to deal with a bigger situation. When you have a defined contribution plan, we only have to talk about the money that goes in. And so that's why the change was made. Personally, it broke my heart, but so it is. The good news about this is that since it's money that's being put in, workers do have the option, the availability of receiving those funds later as a lump sum and can make the choice of whether they want to buy an annuity to have a defined benefit plan. But that's why it gives more options and it costs less up front, significantly. Thank you very much.
Representative Shaban.
Thank you, Madam Speaker. And I note, and I thank the gentleman for his response because I believe that's probably, I think he nailed it. I mean, there it was. You know, we're actually using all the fancy words you typically hear in an ERISA discussion: defined benefit plan, defined welfare plan, and I suspect the Attorney General may be looking at this as well. But when it was originally drafted as a traditional IRA, pre-tax dollars going in, the relatively low-income people that this bill is supposedly designed to protect actually got the protection, or actually got the benefit, I should say, get the benefit of having a, let's call it forced retirement thrust upon them pre-tax. Pre-tax. That's kind of cool. You know, you put in $50 and guess what? That $50 comes off your tax return. But unfortunately, that generated a fiscal note for the state of, I think somewhere, it was a non-fiscal note as I recall. It showed between like $0 and $10 million. It was this massive span, but basically what it was a fiscal note because if you're putting in pre-tax dollars, well, guess who doesn't get the money? The state. So we changed the bill. Let's protect the state. We had this discussion last night. We were changing bills last night. Let's protect the state. So instead of protecting or benefiting the supposed employee that we're trying to benefit, we protected the state and changed it to a Roth IRA where it's post-tax dollars. So now people with low income, the people that this is actually designed to help, aren't getting the help that they want or they need, or they could have had, frankly, if we were actually willing to do this as a traditional IRA, or for that matter, have their employer do it, or for that matter, get their own IRA, or for that matter, have a traditional ERISA plan. But I think it's notable that this amendment basically cut the legs out from under the people that this thing's supposed to protect. In fact, what it did is to protect the state from a fiscal impact because, as we've heard all night and all month and all session, we're in a bit of a jam financially, and that can't happen. So through you, Madam Speaker, moving on. I'm looking at lines 358 through 363, and I'm almost done. I'm not going to belabor. We're not going to go on for hours, sir, I promise. It talks, and there was some discussion about this. This is the section that talks about how the state shall not be liable, yada, 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 and how the authority shall not be liable for the payment of the benefit, i.e. liability protection. Through you, Madam Speaker, why was the liability protection put in place to protect the authority? Through you.
Representative Tersiak.
Thank you very much, Madam Speaker. Which lines are we referring to again through you, Madam Speaker?
Representative Shaban,
Thank you, Madam Speaker. Lines 358 through 363. The end of Section 5.
Thank you very much, Madam Speaker.
Representative Tersiak,
Thank you very much, Madam Speaker. Again, this seems reasonably standard language to me. The state's just not going to be liable for the payment of the benefits. There's only protection from liability here for the payment of benefits. So there is no guaranteed rate of return. That's what that means. Through you, Madam Speaker.
Representative Shaban,
Thank you, Madam Speaker. Well, I think it goes a little further than that. I know it's late, and I appreciate it. The gentleman's been up a long time, and I appreciate it. So I'll just read it. Lines 360 to 363. The authority shall not be liable for the payment of any benefit to any participant or beneficiary or the participant. Above that, it says similar language, and shall not be liable for any liability or obligation of the authority. So it's a little broader than just the payment of benefits. Now, if you look down in Section 6, there's a whole list of duties. Duty of care, theoretically. In fact, I think the original bill delineated them a little better than what's done in the amendment. But regardless, says what the authority can and cannot do, should and could not do, what duties they should take, prudent investments, that kind of thing. Well, you don't have to be a lawyer to understand that if you have an obligation but you have no liability for the breach of the obligation, you don't have an obligation. The right-duty analysis is the central thesis of Western law for the last 600 years. So what we've done here is say, you have a duty, but guess what? You don't have a liability, ergo, guess what? These retirees don't have a right. Where there is no duty, there is no right. And that is just black letter, first week law school stuff. And guess what? That's also common sense. You have the obligation to do X, but guess what? If you don't, no big deal. But here it is. We're taking a lot of money. It's not a force, but you got to opt out, taking retirement money from people who may not know better. But at the same time, if these folks, some of the other folks suggested, let's put them in a traditional Roth IRA or a better IRA, or give them some basic, some help getting to a spot where they can actually invest and save for the future. Well, guess what? When you do that, when you go to a Lehman Brothers, which is now gone, or you go to a Vanguard, or you go to Fidelity, they've got obligations, but you also have rights. They also have liabilities, whether it's fiduciary or otherwise. Here, we are saying that this authority that we're setting up can't be sued. There is no liability. You have, do the best you can with all these people's money, but if you screw up, no big deal. There's a harm, but there isn't going to be a foul. That's not good public policy. That's, in fact, horrible public policy, and I'm not even sure it's legitimate under our state constitution. But we'll talk about, Attorney General will pass on that one as well. Moving on to the bill, if I may, looking if I could at section, and we're getting close here, I promise. Section 10, which starts at lines 511. The Attorney General may investigate any violation of Section 6 of this Act. Continues on. Says that the Attorney General may bring a civil action in the Superior Court for the Judicial District of Hartford, and nowhere else, under this section, in the name of the state against such member or agent. The remedies available to the court shall be limited to injunctive relief. Through you, Madam Speaker, is there any private right of action for the actual employee who's been contributing to this thing to protect their money if someone does them wrong? Through you, Madam Speaker.
Representative Tersiak,
Thank you very much, Madam Speaker. Monies are protected under this as they are under other Roth IRAs. The board is able to be sued, and the Department of Labor this would also fall under the Department of Labor's wage theft statutes, which I'd be happy to strengthen, but not at this time with this bill. But when saying people are protected from this and that, the words in here that matter are, the board can be sued. Through you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. Well, the words in here say the board may be sued by the Attorney General in the name of the state. It does not say that the board or one of its members can be sued by a participant or an employee or a plan beneficiary, as you can get under, guess what? ERISA. That's why the act was passed 45 years ago. It provides a remedy mechanism. Typically, you go through your plan first, and then if you get denied, there's actually a procedure that eventually can ripen up to a breach of fiduciary duty claim. That law has changed, but it is ubiquitous throughout the United States, except now here in Connecticut, if you're subject to this bill, 5 employees or more, Roth IRA, we're trying to make a whole new set of rules that doesn't apply. Because guess what? If you're contributing to a Roth IRA, traditional IRA, some other kind of employee welfare plan, and someone does you wrong, you do have a cause of action. In Connecticut, you don't. Not under this bill. You can get an injunction. What's the injunction say? Stop doing that. That's all it says. Does it get your money back? Through you, Madam Speaker, if one of the employees that are going to be subject to this plan, actually, let's say one of the investment vehicles goes bankrupt, like Lehman Brothers. Through you, Madam Speaker, will the employee or the plan beneficiary have recourse through SIPC, the Securities Investment Protection Corporation that's been established since 1930-something? Through you, Madam Speaker.
Representative Tersiak.
Thank you very much, Madam Speaker. I don't know. Through you.
Representative Shaban.
Well, thank you, Madam Speaker. That was a rhetorical question. I'm not trying to be too cheeky, but in fact, the answer is I don't think so, but maybe I don't know either. But again, not in here, not in this bill. Not in this bill. People who normally get protection for retirement funds, for their investment funds, for the other things, one of the vehicle or the entity goes under, like Lehman Brothers, you get a SIPC suit, you basically go to federal bankruptcy court and chase the fund and try and get some of your money back. Here, we don't know. Through you, Madam Speaker, is this authority going to be considered a direct agent of the state or some kind of quasi-agent of the state? Through you, Madam Speaker.
Representative Tersiak.
Thank you very much, Madam Speaker. This authority is not an agent of the state. The purpose of having an authority is to get the distance from the state. Thank you very much, Madam Speaker.
Representative Shaban.
Yeah, thank you, Madam Speaker. So that's right. So we take the authority, we distance it from the state, we exempt the state from liability. We also exempt the authority from liability other than injunctive release by the state attorney in the name of the state, ergo, no protection. Now, through you, Madam Speaker, if the gentleman knows, and I'm not sure he does, because I'm not sure either, this is actually an open question, can this authority, by virtue of not being an actual agent of the state or a division of the state, can it declare bankruptcy or seek bankruptcy insolvency protection? Through you.
Representative Tersiak.
No, the authority itself cannot declare bankruptcy for itself. The authority cannot dissolve itself. We pass laws about that, and that's the only way the authority can end itself. It can't say we're bankrupt, we're out of this business. Through you, Madam Speaker.
Representative Shaban.
Thank you, Madam Speaker. If the gentleman could, if it's in the bill, if you could point me to it, it might be the amendment. I might have missed it because the amendment got on us tonight. Could the gentleman point to in the bill where that says that this authority, which is not an agent of the state, cannot declare bankruptcy or seek insolvency protection? Through you.
Representative Tersiak.
Thank you very much, Madam Speaker. If I might have a minute to look through the 27 pages of the bill to answer the member's question. Thank you very much, Madam Speaker.
You may proceed, sir.
Thank you, Madam Speaker. I found it on page 8, lines 220 to 223, that the authority shall continue as long as the program remains in effect and until its existence is terminated by law. That's how the authority may end. Thank you, Madam Speaker, through you.
Thank you, sir. Representative Shaban.
Well, thank you, Madam Speaker. Unfortunately, I thank the gentleman for diving in. I know you've been up for a long time, but that doesn't do it. That doesn't do it. The plain language of that sentence does not do it. There is no language in this thing that says this authority cannot seek insolvency protection. So here's what we have. We have forced employee savings. That's going to be another burden on our employers. We've got opt-out provisions that may or may not get picked up, especially on small employers or people who are just working part-time. We've got a provision that at least gives the indicia of protection of the state when there is none. We have a program here that gives the indicia of protection of the state or the protection of ERISA or other federal laws where there is none. We have a provision here that's going to take people's money, which is not protected like it would be under an ERISA program, under SIPC or other federal paradigms. We have something here that all this does, frankly, is give the state a little bit more money. Through you, Madam Speaker, the last question, if I may. When the authority gathers the funds and whatever they have to do for reporting, I know there's reporting requirements in here, where is that amount of money going to be booked? Is it going to be on the state's books or off the state's books? Through you, Madam Speaker.
Representative Tersiak.
Thank you very much, Madam Speaker. The state puts money on its books when it's the state's money. The authorities have their own books. That's where they put their accountings. Thank you, Madam Speaker.
Representative Shaban.
Well, thank you, Madam Speaker. And frankly, I appreciate the answer, but I wish that was the case, because I know, in fact, the last budgets I've seen for the last 6 years, we've actually budgeted for things such as cheats, which, guess what? That isn't state money. In fact, the money doesn't even exist until someone doesn't do something that gets a refund back, that gets cycled back up to the state pursuant to a statute which doesn't exist. But guess what? We budget for that. We budget for that. And it is considered on the books. In fact, when we were talking about spending cap requirements, we were moving dollars on and off book to figure out what was in fact required. Through you, Madam Speaker, this really is the last question. You prompted it. Would any of these monies, if the gentleman knows, we might not have thought of this yet, would any of these monies be counted in any way, shape, or form to the state spending cap in terms of the gross dollars on hand? Through you, Madam Speaker.
Representative Tersiak.
Why, thank you, Madam Speaker. Through you, no.
Representative Shaban.
Well, thank you, Madam Speaker. That is the best news that I have heard in the last 40 or so minutes, and I know the gentleman's been up a while. This is a tough bill. I think it's a bad bill. I think a state, you've heard it before, I'm not going to repeat it, but in the fiscal condition we're in, the last thing we should be doing is establishing a state program to impose another state Band-Aid so we can manage more of people's money. I think it's the wrong way to go, but I thank the gentleman's longevity and tenacity, and I urge rejection. Thank you, Madam Speaker.